Welcome to Law for Life with Georgia.
Welcome to where attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Lisa Mosby, your host, and today we're talking about a common misconception in estate planning that having a will means your family is automatically protected. Georgia's going to explain why just creating a trust isn't enough. Welcome, Georgia. Thanks so much for joining me today.
Nice to see you, Lisa. Yes, thank you very much for having me.
Georgia, I have heard that signing trust documents is only half the battle. What actually happens in Wisconsin probate court if a trust isn't properly written or never funded?
One of the biggest misconceptions is in Wisconsin is if you've got a trust, you're covered. That is not the case. Typically, what I do when I'm doing an intake on someone that's coming in for an estate plan, I'm looking at their entire financial portfolio and making sure that all the assets that are within that portfolio are fully funded. So there's a way to do that. And as an attorney, there's a right way and a wrong way. People think that they could just get online and, slap something together. Unfortunately, mistakes happen and things are not done correctly. And that is one of the biggest issues that we have these days. People think that they can go the cheap route and just get this done by themselves. And then all the mistakes happen, and we see it on the back end when they come to consult with us to do a probate case because they failed to fund the trust properly. So it is critical to make sure that all the assets are funded in your trust. Otherwise, you're going to end up in probate.
And is it possible for a family in Wisconsin to end up right back in the complex, expensive probate process they were trying to avoid simply because one major asset was left out of the trust?
That's right. That's right. That happens a lot. In fact, I've got a client right now who failed to put the house into the trust. They bought a house in one state. They decided to sell that house and bought another house, but forgot to put that into the trust. And it is one of the most critical mistakes people make. They think once you've got a trust, you're done. No, every 5 years, I say to my clients, come back, let's do a review, let's make sure everything is funded properly and you've done everything that you need to avoid probate. And unfortunately, it becomes such a headache because the process for probate takes 12 to 18 months before these beneficiaries are able to get the money or the property, whatever it is that is in the estate. And unfortunately, it's very invasive as well. It drags out a long time, and it's very expensive. So it really does make sense to hire our firm to do your trust and do it right and get it funded right.
And then families frequently forget to update beneficiaries, like on life insurance policies or even retirement accounts. Why is coordinating these so important when it comes to non probate assets?
Making sure to update your beneficiaries is critical. Critical. A lot of people forget to do that, and it goes to someone who they didn't intend it to go to, or it's not listed at all. There's no beneficiary named at all, which, in my opinion, that's very negligent. That's not something that someone who's selling you the life insurance should be making sure that you have named beneficiaries. But unfortunately, in this not so perfect world, that does not happen. Many times people have a change of circumstances. They get divorced, they remarry, they have more kids, they forget to add one of the kids on the life insurance policy. There's all kinds of snags that can come up. And it really does make sense to make sure that you're triple checking your beneficiary designations no matter what.
And then, Georgia, when we're funding a trust, do you recommend clients transfer all assets at once, or can it be done systematically over several months?
Ideally, it's good to do it immediately. That is by far my favorite. You knock out And what we do is we knock out the major assets. The real estate, for example, is something that we make sure gets funded immediately into the trust. So when a client comes into our office, if they do own multiple real estate properties, we make sure that that flows through into the trust. That way, we're not having to deal with the probate court. Um, Other areas where people forget to do and do funding is with bank accounts, with brokerage accounts. There's all kinds of instruments that people use and financial assets that people have. And it really does make sense to make sure that everything is funded properly. So, in my opinion, you should do it right away and you should continuously be checking it. Otherwise, we will run into the issue of, oh, I forgot to put this asset into the trust. And now I have to go back and do a probate because of, a situation like that. So ideally doing it immediately is the best way.
And then what are the most common challenges clients face when transferring Wisconsin real estate deeds into their trust, especially if there's a mortgage involved?
Mortgage companies tend to have these clauses, they're escalation clauses in place. And, they'll say things like, well, you're putting it into a different instrument, you're changing the deed from one to the other. And it could trigger an escalation clause. But 9 times out of 10, if you communicate with your lender and you let them know that, this is a trust, it is just a flow through. We are still the owners of this trust. And they've got a first position as far as the mortgage goes. So it's not as daunting as people think. I think it's really important to make sure you have that open line of communication. So now in the state of Wisconsin, and I think that this is across all states, we have a new law. It's the FinCEN Law. And for estate planning purposes, it generally doesn't apply to us. But if you're purchasing property for cash, now you need to put private information into a government database. So it does trigger when you're doing a quick claim deed. If say it's a trust and say it's not somebody's trust that I drafted, I tend to be very skeptical about things like that because the question mark is, are you doing this as a money laundering scheme or, what is happening here? So as an attorney now, we have to be very diligent because if you don't follow the FinCEN law, there are criminal penalties that, would apply. And it actually is to the attorney for failing to report. So it's critical to do it and do it right. A lot of people don't know about this new law. It just was put into effect March 1st of this year. And it is definitely going to hopefully help at least our country make sure that we're not, accepting dirty money from other countries, money laundering money.
So, Georgia, what are the essential documents and permissions needed to transfer a family business or professional practice into a trust without disrupting operations?
It's really important when you've got an LLC. Um, People tend to slap these LLCs together. They don't have an operating agreement in place. Unfortunately, then I have to give them the bad news. You need an operating agreement in order for us to move forward with transferring, for example, a family practice to the beneficiaries, the children, or whomever it is. That's kind of succession planning. 9 times out of 10, kids don't want the business. So giving the business to someone who doesn't want it and doesn't want to run it is, it's a travesty. I mean, you've worked so hard to build this practice up or this business, whatever the family practice or business is. And unfortunately, you have kids who do not want it. They don't want to run it. And next thing you know, it's for sale. Unfortunately, we have key people. And if those key people are no longer in that business, it could be detrimental and its value could obviously diminish greatly. if you don't have the right paperwork in place. So making sure you get consent from members of the LLC, that's critical, very critical. A lot of people miss that step. And making sure that, you've got records that are up to date, including who the members are, making sure you get consent from all members when you're doing transfers into your trust. And again, there are clauses that are triggered, like a right of first refusal. Current members of the LLC might say, I don't want to be partners with your kid. So it may trigger a conversation, I think, especially when you're asking them to sign a consent form saying, hey, if something happens to me, this is going to go to X child or whomever it is that they want running it. Again, the existing partners need to be okay with that. So that's definitely a conversation that a lot of people try to avoid, and it definitely is not something to avoid. It's something to hit head on. So that's something we do handle in our office, making sure that we transfer the shares accordingly and make sure we get member consent.
There's so many different nuances to trust these days in a digital age with crypto assets and online accounts. How do you use technology to help the funding process and make it easier and more verifiable for clients in Wisconsin?
It's unfortunate, but people miss assets because we are in a day and age of digital everything. People aren't getting their bank statements mailed to them anymore. Everything is done online, and you have to have access to an individual's email address. You have to have access to passwords. I can't tell you how many times, and I'm sure you've seen this too. Facebook, for example, they've got so many deceased people and they cannot take them down because they don't have the login, the heirs don't have the login and the password to take that account down. So and Facebook has some really strict requirements for that. But this applies to everything: social media accounts, email accounts, any digital assets that you have, bank accounts, all of that. So what I've done in my office, I actually wrote a book on this. It's a digital property master book. And what it does is it's something I give to the clients, and I say to them, update this once a year, logins and passwords for everything, all of your digital assets. And cryptocurrency is very tricky. There's specific language that needs to be put in the trust in order to address crypto currency. And so any of these online accounts, again, the minute that the individual dies, technically the accounts, they're no longer able to access them. So my advice to a lot of clients is to make sure you do have your logins and passwords stored somewhere and have them in a nice order or fashion. It's basically just a step-by-step checklist that says, okay, here are all of my assets. Here are the beneficiaries who I've named for these assets. Here are the logins, the passwords. This is how you get into the accounts. So again, it's an ongoing problem, and there are so many assets that end up getting reverted to the state of Wisconsin because people haven't been able to uncover all the assets of the decedent. It is getting more and more difficult, definitely more and more difficult. So another thing that I advise clients, if you're feeling comfortable with using something like Dashlane or LastPass, that's certainly something you can use, but you got to make sure that you give the password, the master password, to your beneficiaries, to the people who are going to be taking from your property. It's critical. Otherwise, you're locked out. You can't find anything, and trying to investigate and get that information in a house, it could be difficult, especially if you're paperless. So it's important to make sure that that stuff is communicated with at least your successor trustee or with a personal representative, depending on which direction you go. It's good to let them know and communicate with them and let them know, here is where you will find this stuff.
And you mentioned revisiting all of these documents every year, when you buy a new car or you're adding a new asset to yourself, to your portfolio. The thing that I want to wrap this up with is, do you need to have a trust if you don't have a house? Maybe somebody who's 20, 30 years old, they're just getting started in life, but they have cryptocurrency, they have an automobile, they may have other assets. Who does need a trust? Do we all need a trust? I want you to speak to that as we wrap up this episode.
Honestly, what I do is when I do my intake with a client, I will evaluate. I have them fill out a financial questionnaire form. And depending on what they have in assets, I will advise them which direction to go. A will is not enough. A will does not avoid probate. So if you think you're going to get away with this and just do a will, it is not enough. You need to do more. You need to make sure you're naming beneficiaries. You need to make sure that everything is accounted for. And in the state of Wisconsin, if you have assets over $50,000, you will be going to probate in order for those assets to be transferred from the decedent to the individual beneficiaries. So it's critical to make sure anytime you have a major life event, a death, a birth, a divorce, those are triggering events that I call them triggering events, and they can change the dynamic, especially people who are getting married. There's a lot of young people now that don't realize that, the minute that you get married in the state of Wisconsin, we are a community property state. So 50-50, any assets that you have going into that marriage, 50% of them would go to your spouse in the event of a divorce. So a lot of people fail to recognize that. Unless you've got a prenup in place, be prepared to split those assets should things go south in your marriage. So it's really important, if you do in fact want to create a division of assets and say, okay, I'm going to have a prenup or a postnup saying these assets are coming with me. I brought these assets into the marriage now. These assets are coming with me. And making sure that you're revisiting it. 9 times out of 10, people pick up new assets. They forget about them. And they think because they've gotten this trust for me 10 years ago that they're in good shape. Absolutely not. You need to come back and see me so that we can reevaluate, look at the assets at your financial portfolio as you get closer to getting older, and just making sure that if there are assets that you've accumulated after the trust was formed, and if those assets were not funded properly, they need to get funded. So that goes back to your first question to me, was making sure that we're funding everything, and any new assets, making sure that those are included in the trust. It is critical, because I've had scenarios, true story, this was an absolute nightmare. This man had a life insurance policy, had named his girlfriend at the time as the beneficiary. And since then, he was married, 3 kids later. And unfortunately, when he did pass away, the girlfriend was not kind. She kept the money. She didn't give the money to his wife. She kept the money because she was the properly named beneficiary. And that is a contract between the decedent and the life insurance company. It's so critical to make sure you update all those documents and make sure that it's done right. So again, critical that when you do an intake with someone like myself, I will make sure that everything gets funded. If it's not funded, there are named beneficiaries.
Georgia, thank you so much for your guidance today. That's it for today's episode of Law for Life with Georgia. To learn more about Georgia and the Konstantakis Law Office, LLC, visit konstantakislaw.com. Thanks so much for listening, and be sure to subscribe, share, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.